On Thursday, it will be exactly 2 years since Parliament passed a motion to establish a constitutional review committee to look into amending the Constitution to allow for land expropriation without compensation. This was a motion promoted by the EFF and then amended and adopted with the support of the ANC. What ensued in the period following that, between February and November of 2018, was a dramatic process around the country, with a constitutional review committee soliciting input from the public and consulting. Over 600,000 written submissions were received. This is unprecedented in our democracy. Not since the constitutional negotiations in the mid-90s has there been this level of public engagement on parliamentary matters. And 2/3 of those written submissions were against any constitutional amendment. Not surprisingly, the tone of public engagements at the hearings that were held around the country were very much different, where the vast majority of people, mostly black South Africans, were strongly in favor of constitutional amendment. The debate, in a way, came down to a census or a proxy debate about the legitimacy of our economic system and the legitimacy of the existing property rights dispensation. I started to use the term political theatre to describe what we were seeing. And I used it for a particular set of reasons. It was a term I'd started using in about 2013, which was the centenary of the Natives Land Act. We had a big land divided conference. There was the reopening of land claims in the context of a crisis of land reform and a failure to resolve claims. Alongside failing land reform, a precipitous decline in the budget, and evidence of mismanagement and corruption, the ANC, responding to the EFF coming onto the political scene, promoted this idea of reopening the land claims process. So this was important because the ANC was starting to articulate new ideas about the nature of property rights and the constitutional settlement of the 1990s in the context of being challenged for the first time from the left. The reason why political theatre, I think, is an apt way of describing what we're seeing is that there's a disjuncture between the way things are being talked about and the realities and actions on the ground. If you were to listen to the debates in Parliament over the past 2 years, you would expect that, in fact, the state has been trying ever since 1996 to expropriate properties and restore them to the dispossessed. And it has been trying to pay little or no compensation, but that the courts, citing the Constitution, have been preventing it from doing so. Of course, none of this has ever happened. Political theatre also suggests that everyone knows their role. They speak from a predictable script, and the reality of the script is, in a sense, not the point, but rather the theatrical effect it can conjure up. And so I think that our role as academics is to interrogate, with no holds barred, the ways in which there are both contradictions within within these discourses, but also how far they are from the realities of the ground. Around the same time that all this was happening in the reopening of land claims and the starting of blaming the Constitution for the failings of land reform, the Malema case came to the courts. I wrote an affidavit in support of the Mhlanga-Lisweni community. Government was claiming that it could not restore this land to the community of largely former labour tenants who'd been dispossessed of it. And government was claiming that it couldn't restore the land because it was too expensive. It was also using its past failures of land reform and failures of land use and production as a reason to avoid its constitutional obligation to restore land to the dispossessed. So, acting for the Amicus Legal Resources Centre, the argument was that in fact the state must expropriate and it cannot hide behind unaffordability. In fact, it should use just and equitable compensation and not offer market price. This case would have given the first opportunity for the Constitutional Court to rule on the matter. However, Nkwinti, then Minister, withdrew the case a week before the hearing, when the Constitutional Court would have been able to rule. Instead, the ANC and government chose to pay out just about R1 billion to a single white family. That was 1/3 of the national budget, rather than give the courts the opportunity to interpret the first time the property clause. So let's go back a bit in history. I think it's useful to start by looking at the late 80s and early 90s. By the late 80s, the ANC, from a mixed position around whether or not it advocated for nationalisation or not, this had always been a tension, particularly after the Communist Party joined together with the ANC. By 1998, the ANC in its negotiating position had agreed for certain protections for private property, but not for corporate property. So it distinguished between personal and corporate property. By 1991, Zolas Gwenya, who was heading up the Economic Commission for the ANC, assured property owners that, he said, unlike the National Party government, the ANC has no intention of achieving its aim of redistribution of land through policies of forced removal and confiscation. But still, the ANC rejected the idea of putting property in the constitution. And partly it drew from lessons elsewhere, that property should more properly be regulated in the common law and not be given constitutional protection because of the fear that it would insulate the existing unequal and unfair property dispensation. Around this time, the idea was that rather than confiscating land, there should be a tax on all landowners, and this should be fed into a fund so that all landowners would be part of paying to those who are expropriated. In other words, the idea that society as a whole, or those who own property, the wealthy, those who own tax, would be paying towards redistribution. And then we get to these two interesting constitutions of the 1990s, the Interim Constitution of 93 and then the final Constitution of 96. And there's an enormous difference between them. So what came out of the Codesa negotiations in 93 was an interim constitution that starts with the phrase, everyone shall have the right to acquire and hold rights in property. This is a positive property right, and it is a blanket property right that, of course, not only applies to private ownership, title, or indeed only land, but nevertheless, it is a right to property. And in 1995, the National Party put forward, similarly, the idea of property, including the right to acquire, hold, and dispose of property, is guaranteed. That was the National Party's position in the negotiations. Now, if you look at the property clause, I'd invite you to distinguish between Section 1 of the property clause and the subsequent sections. So what we have, what we have in Section 1 of the property clause is in fact a negative right to property. It does not say that there is a right to property or that a right to acquire, hold property is guaranteed. It in fact presents a negative right to property. It says you do not have necessarily a right to property, but you have a right to a process by which your property may be taken away from you. And that process of it being taken away from you should be non-discriminatory. That is what it adds up to. But something else is embedded within the property clause that I think is of enormous importance, and it's found in Section 25(5). If you look at 5, 6, and 7, you'll see broadly that these reflect the three pillars of land reform, or land redistribution, tenure reform, and restitution. Now, the idea of not only having restitution of land rights and the right to tenure, but also a wider process of land redistribution that is constitutionally mandated, came from Jeff Budlander of the Legal Resources Centre, who wrote in 1992 an argument for a right of equitable access to land. And I think that this idea has been very underexplored and is incredibly important for our thinking going forward. He wrote this article called The Right to Equitable Access to Land, and points out that without such a right, the only way that homeless and landless people may access land, unless the state decides out of its own largesse to give it to them, is to claim it through occupation. He looks at how this has been the primary way in which changes in property rights had been happening. He said a problem of the bureaucratic process is that it contains supplicants on the one hand, those who ask for things, and dispensers of largesse on the other. The homeless come to the government with a plea for assistance, and the government, in its wisdom, makes a decision. In other words, we're not talking of entitlement, we're simply talking about a less or more benevolent administration. To have to rely on requests for government largesse is ultimately disempowering. It leaves the dispossessed with only two possible forms of action: to plead with the government for relief or to resort to land occupation. And so he put forward the idea of having a constitutional and judicially reviewable right of equitable access to land. So you can see it, where the Constitution says the state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access to land on an equitable basis. So in this way, the attempt was made within the property clause to include rights for both the property, and those rights were primarily around the manner of dispossession of rights, but also positive rights for the dispossessed, rights of equitable access to land, rights to secure tenure, and rights to restitution. What has happened since then? Well, I think the best review of the period of the past 2 decades or so comes from the high-level panel, the Motlanthe panel, which in 2016 and 17 undertook an extensive national review. And what it noted was that around land reform and redistribution, not only has the character of policy changed towards a more narrow and elite program, but it has retained a market-based approach that is not constitutionally mandated. So if you check section 25, there is no mention of a willing buyer, willing seller approach to land reform. In fact, of course, that has been a policy decision by the state to not use the powers that are set out in sections 25, 2 and 3, which empower it to expropriate, including for land reform processes. So what the high-level panel pointed out is that while we have an elaborate framework to guide restitution of land rights for those who are unfairly dispossessed, while we have an extensive framework to say that people have tenure rights, including farm occupiers, people in informal settlements, across all categories of land, what we do not have is any clear framework to enable people who are homeless and landless to exercise this right of equitable access to land. And that is one of the things that I feel is utterly missing in this debate on constitutional amendment. Following the motion in Parliament in 2018 and following the constitutional, or during the Constitutional Review Committee process of that year, the President appointed an advisory panel on which I served, which clearly had a political purpose running alongside and in parallel with this parliamentary consultation process and all the way up to elections. The Presidential Advisory Panel served politically to show that something was being done by government even while this parliamentary process was underway. My view is that it must be understood in the context of intra-ANC politics, not only the ANC positioning itself ahead of elections against the EFF. So more about that could be said, we can debate it. In our opening meeting, Ramaphosa said to us, there are those amongst you who feel it is not necessary to amend the Constitution, and some who do. That is why we have put you together. And indeed, that's what we ended up fighting about, among other things, over a period. What we discovered was most alarming. For instance, the Valuer General, who's responsible for government valuations, came and told us quite blandly that they've been using market price until recently, and they'd started using what they call current use value instead of market price. In other words, they had been offering and paying property owners market price. They were now offering below market price and were unable to secure purchases on this basis. They were not using that opportunity to move to expropriation. The Chief Land Claims Commissioner, Nomfundo Gobodo, told us that 27 properties nationally have been expropriated under the Restitution Act. And she said, in fact, the problem they face is that property owners want not only market price, they want solatium, or compensation money over and above market price. None of these 27 expropriations have gone to court, and the courts have not judged on them. In other words, the state has expropriated, and when there's been disagreement on compensation, the state has negotiated until there is agreement. In other words, it is not using these provisions of 25, 2 and 3. So the state has not been using these opportunities. Tembeka and Mukaitobi and myself on the panel were tasked with coming up with a response to this, and our view was that the failing of government clearly is a political failing, but also there is no clear framework for anyone to draw on to push their claims. We argued that what we need is clear interpretation of sections 25, 2 and 3. We also noted that government has been debating this issue of compensation as if compensation needs to be paid somehow related to market price, that it should be paid in cash and that it should be paid up front. Whereas, of course, the Constitution says that it's the amount of compensation and the time and manner of payment that must be just and equitable, not that it has to happen all at once. So overall, what it seemed to us is that while the Constitution provides a clear stick, a set of powers with which the state can acquire property, in practice the state was using all carrot and no stick. So it was choosing not to use its expropriation powers, and it was only offering more and more to property owners in order to secure their agreement. Of course, when the Valuer General started using a lower amount and offering lower below market levels, this amounted to simply cutting the carrot in half. Nobody was biting. There was still no stick. So it's in this context that we have a situation in which it is understandable that there's widespread dissatisfaction with how the state has gone about its land reform process. The economic freedom fighters perhaps have the most detailed and articulate position on the issue of expropriation without compensation and the nature of a constitutional amendment. And they argue, firstly, that the Constitution as it's currently written, this is from the Frequently Asked Questions document from the end of 2018, the Constitution as it is currently written does not allow either for expropriation without compensation or for the narrow piecemeal expropriations advocated by liberals, or the broad-based expropriation advocated by the EFF. So what they've done is they've looked at the 5 criteria that are meant to guide the determination of compensation that's in section 25.3, the current use of the property, the history of its acquisition and use, its market value, past state subsidies, and the purpose, and said that actually the market value is the only easily quantifiable one, and all the others in practice are going to fall away. So the EFF, it says, wants a constitutional amendment that it would make it legally permissible for the state to expropriate land, but not other forms of property, without compensation. This land must be placed under the custodianship of the state, which will administer and redistribute it equitably to all South Africans. What I think is striking about that sentence is that it contains 2 distinct parts. The land must be placed under the custodianship of the state, and then it talks about how the state is likely to or should use those powers, in other words, to redistribute it equitably. So that is the ANC position. There are 2 major, EFF, yeah. There are 2 main criticisms of this position. The first actually comes from an interpretation related to mineral rights. You'll remember that the Mineral and Petroleum Resources Development Act, the MPRDA, effectively nationalized our mineral resources, just as the Water Act nationalized our water. Now, Agri South Africa, representing commercial farm owners, took the MPRDA to court, and the Constitutional Court ruled that with relation to mineral rights, nationalization or vesting of resources under state custodianship does not amount to an expropriation. No compensation is required. And it passed constitutional muster. So under our existing 1996 constitution, we have nationalized both water and mineral resources. So the EFF's objective, which is to nationalize land and place it under state custodianship, can be achieved under the existing constitution. The state could nationalize all land via a 50% vote on a law in Parliament, just as it did with minerals and water. In both cases, there were, of course, outcries. In both cases, of course, there have been legal challenges, but these have failed because our constitution allows for nationalization in the public interest. The second criticism of the EFF position is the excessive faith that it puts in the powers, in the way in which the state will use its powers. So just an anecdote, a week ago today, I was with Katlego, who's here somewhere, in the Eastern Cape. We were with Chisamani School of Activism and other groups holding a land tenure school for 63 activists from across the province who were meeting about land reform. What they wanted to know was how have people in other countries struggled to resist their governments and their traditional authorities selling out their property rights from underneath them. They wanted to know what was this expropriation without compensation thing, and can it protect us when our chiefs give away our land to mining companies? What happens when the minister, Gwede Mantashe, is dead set, together with others in government and traditional leadership, to take land without our consent? Can we have compensation, or will they take our land over and expropriate our property rights without compensation? So all of this shows a contrast between some belief in the way in which the state will act with the resources under its custodianship and the actual politics on the ground. Let's move on to the ANC. The ANC, in its 2017 elective conference, alongside the election of Ramaphosa as president, passed a resolution calling for a process to look into amending the constitution to allow for expropriation without compensation. This had emerged as part of ANC discourse in around 2016, when Jacob Zuma started to talk about radical economic transformation and started to say that the constitution was the reason why land reform had not advanced. Now, in the context of the ANC conference in December 2017, this motion pretty much brought that conference to collapse, to the point of collapse. There were physical fights. There was an argument that the conference should be called off and reconvened at another point in time. You'll remember that the whole conference, and particularly the presidential election, the position of president of the party, hung in the balance depending on the accreditation of certain branches, so it was touch and go. Part of the trade-off then within the ANC was to allow the presidential vote to go ahead, it had already gone ahead, to allow it to stand in return for this motion on expropriation without compensation going through. In this way, the ANC moderated a position between the two primary factions. On the one hand, blaming the constitution for its own failings and thereby agreeing with the EFF, adopting the rhetoric of particularly the radical economic transformation faction, while also infusing it with some of the pro-market and investor-friendly language of the Ramaphosa faction. In the motion in February 2018, the ANC amended the EFF motion by adding 3 caveats that did precisely this. On the one hand, expropriation without compensation should promote national food security, it should promote national agricultural productivity, and should not threaten investment. So in that way, the ANC aimed to square a particular circle. Now, my view at the time, and also, oh my goodness, but I used it. Yes, okay, I'll be fast. So, one of the most clear articulations, I think, of why the ANC is wrong comes from an article by Tim Bacon, Mukai Toby, and Michael Bishop on the constitutionality of expropriation without compensation, where they say the question under the Constitution is not whether expropriation without compensation is constitutionally permissible. It is. The question is when it is permissible. And of course, when it is permissible has never been spelled out. But of course, what it allows for is 2 things. It allows for either the EFF's nationalization of all land and vesting of land under state custodianship. It also allows for the ANC's version of expropriation without compensation, which is essentially judging on a case-by-case basis when compensation should be paid and how much is to be paid. In other words, one-by-one compensation of properties with compensation below market price or even minimal or even zero is absolutely allowed within the Constitution, but it would have to be shown on a case-by-case basis. Of course, this is where the concerns emerge about being stuck behind lengthy, protracted court processes. So briefly, while the EFF says you can't do this under the Constitution, the The ANC agrees that the constitution barrier, in my view, this is the most inconsistent of the positions of the parties, since the ANC has been so very careful not to use those powers. The third position, of course, is the DA's view, shared by many representing propertied interests, that the Constitution is not and has never been a barrier to land reform. The barriers to land reform have been and continue to be ANC government corruption, constrained budgets, and a lack of political will. So you'll notice that, in fact, many of the DA criticisms coincide with criticisms from the left that criticize government, even though they disagree on the remedy. So what are the different remedies of the three parties? The EFF says vest the land in the state. The ANC says let's have a mix of different tenure models, state ownership, private ownership, customary ownership, and cooperative ownership, and let's have a mix of acquisition methods, either through the market, through negotiation, or through compensation. Through expropriation. When we expropriate, we'll have a mix of compensation levels. The DA position is to retain the existing market system, expropriate it where needed with compensation. So I will go into greater detail later. I just want to clarify also a dispute that has emerged arising from Matola Mocheka's statements last month after the ANC Lekgotla, where he said that in fact the ANC now wants to amend the constitutional amendment bill that you have in front of you to make it clear that in fact it should be the minister who determines compensation, not courts. Of course, this is not really a radical proposal. The Minister of Public Works already determines compensation. Often this is an administrative function, not a judicial one. But of course there could be a review by the courts. So all of this suggests that we have very different political traditions talking past one another. On the one hand, we have a discourse which is a nationalist discourse at its heart, invoking concepts of decolonization and centering race. This is a position that draws from Frantz Fanon and concerns about what a nationalist bourgeoisie would do following independence, and the idea that a reversal far wider than merely restoring land is needed. This is also, I think, very much why the land expropriation without compensation issue resonated so much with other decolonial projects, including the wider discourse of the feasibilist full movement. It also draws on the kind of work that Archie Mafeje, the South African exile, articulated in part. Then we have a range of views that broadly support liberal notions of property and rights and liberal ideas of the limitations of state interference with private ownership. We see, for instance, Mike Pompeo, the Secretary of State, last Wednesday saying that this will be disastrous, Ernst Rutz and AfriForum. But also, very similar, in fact, arguments coming from, for instance, the Democratic Alliance, which says if land reform is not approached carefully, the consequences will be disastrous. The DA will continue to unashamedly fight to protect our constitution and individual property rights while ensuring land ownership for more South Africans. So they're somewhat equating individual property rights with the constitution, which I'd argue is inaccurate. And then we have Dan Crick, president at the time of Agri-SA and also a member of our panel. Now, he is the person who, within our panel, disagreed with many of the components of our recommendations, so much so, in fact, that we had to include a page that itemized 10 areas of disagreement, in which he disagreed with any mention of expropriation without compensation, any proposed amendment of Section 25, the targeting of labour tenants for expropriation without compensation, a moratorium on evictions, any mention of a compensation policy, which is incredible, any forced on-farm settlements in terms for farm dwellers, any attempts to turn informal rights on farms into permanent rights, any attempts to do expropriation without compensation in respect of absentee landlords, and an anti-titling approach to communal land. So what they want is privatization of communal land and otherwise no constitutional or further legal interference with private property holdings. So this, I think, that reflects the classic works on liberal ideas, including John Stuart Mill's ideas, of when the state has a right to intervene and when it doesn't, which I can't go into now. And now I'm going to start wrapping up. What I would like to emphasize right now, I'll do two things in wrapping up. Where are we at now? Parliament has established its, in November of 2018, while our panel was still busy, the Constitutional Review Committee reported after its extensive processes, and its findings are very straightforward. There is no need to amend Section 25 of the Constitution to allow for expropriation without compensation, however, it should be done. So its final recommendation reads as follows. Section 25 of the Constitution must be amended to make explicit that which is implicit in the Constitution. And that's precisely what the current Ad Hoc Committee in Parliament is busy with. Comments on the constitutional amendment bill are due by this Saturday, the 29th, and you can see the relevant page here where the proposed amendment is very minimalist. It says a court may determine that the amount of compensation is null. This is limited only to land reform, right? Not to other types of expropriations. So compensation may be null only if the expropriation is of land and if it is for land reform. Following the end of this month, there may be a change to this constitutional amendment, and at some point the committee, which is ANC dominated, it has an absolute majority, will forward a motion to the National Assembly. There are two main scenarios that we can see. One is that the EFF grudgingly agrees to support an ANC-driven amendment of this kind, watered down as it is and permissive as it is, because it would be so difficult to explain to its own support base why it would not follow through on its demand for a constitutional change. The second scenario is that the EFF refuses to support an ANC-driven amendment, and the ANC might or might not, probably won't be able to pass it without the support of the EFF, in which case we'll be back to where we were at the beginning of 2018. At the same time, of course, we have the Expropriation Bill. Now, the Expropriation Bill is what sets out 5 situations in which there could be no compensation, but it doesn't say anything about the full spectrum of compensation between 0 and market price, so we still are in a policy vacuum. So through this all, we've seen the strange convergence of, at least at a rhetorical level, between the ANC and EFF, talking about the limitations of the Constitution and is, in a sense, hiding behind that as an excuse for government's failure to honour this mandate. We see intentional hyperbole, in my view, from AfriForum, the Institute for Race Relations and others, who argue and pretend, I think, that wholesale confiscation of land is in the offing. I don't think they seem to have looked at the Expropriation Bill and its very, very modest provisions. We can discuss that in question time if you like. So in my view, there are fundamental flaws with the position of the EFF, the DA and the ANC on this very complex issue. At the same time, we should draw our attention to the real politics. And I was struck by a statement by Abaklali Basem Jondolo yesterday on their march in Durban to make demands. And what they talk about is precisely going back to what Badlinda was talking about in 1992. Instead of shoring up further powers for the state, the focus should turn on strengthening the rights of citizens. And in this regard, I think that 2 of the models that have been discussed are the Brazilian model of saying that land has a social function, an essential part of this situation, and the Bhutan model, which provides every citizen with a certain modest entitlement to a minimum area of land. So I'll just leave those out there. But fundamentally, I think that what a movement towards saying an equitable right to land is a real right, people can invoke it, the state must respond, and the state can be held to account for its failure to respond to the demands of the homeless and landless. I think that is a crucial direction forward. If we feel that tinkering with the minor wording in the Constitution is going to substantially change the politics of land, I think we are kidding ourselves. So I think that I'll leave it at that, and I look forward to your comments and critiques. Thank you.